In the heart of the bustling city of Florence, a heated debate raged among the city's most respected jurists. The year was 1390, and the topic was as old as it was contentious: the dowry. At the center of this storm was Paolo di Castro, a brilliant but controversial legal mind who dared to challenge the traditional interpretations of the Florentine statutes. Imagine a woman, Caterina, who married her first husband, Giovanni, and brought a generous dowry to the union. They had children, but Giovanni died young. Caterina, now a widow, decided to remarry. Her new husband, Alessandro, was younger and vigorous, and they had no children together. When Caterina passed away, a fierce legal battle erupted over her dowry. Should it go to her children from her first marriage, or to her second husband, Alessandro? Paolo di Castro stepped into this fray with a bold and unorthodox opinion. He argued that the Florentine statutes, which required only 3 conditions for the husband to gain full rights to the dowry, valid marriage vows, a dowry, and no common children, meant that Alessandro should inherit everything. He dismissed the arguments of his contemporaries like Salisto, who insisted that additional criteria, such as the consummation of the marriage or the husband's expenses, should be considered. Paolo's stance was radical. He believed that the statute's wording was clear and should be adhered to strictly. To him, the intentions of the statute makers were irrelevant. What mattered was the plain language of the law. He rejected Salisto's etymological arguments as frivolous, insisting that the statute makers used ordinary language that anyone could understand. According to Paolo, once the marriage vows were exchanged, Alessandro became the rightful heir to the dowry, no matter the circumstances. However, Paolo's opinion was not widely accepted. Many other jurists, including Baldus and Rosolo de Rosselli, argued for a more restrictive interpretation of the statutes. They believed that the drafters' intentions were unclear and that a broader application of the ius commune, the common law, should be considered. This debate was further complicated by the constant revisions of the Florentine statutes. The 1325 statute had granted the husband full property of the dowry if there were no surviving children, but the 1355 statute introduced new wording that raised questions about the interpretation of the term meritus husband. The 1409 draft of the statute attempted to clarify the issue by adding a requirement that the husband must have introduced the bride into his household before he could claim the dowry. This was seen as equivalent to the consummation of the marriage. However, the 1415 statutes went even further, explicitly stating that the husband could gain full property of the dowry only if the wife had been introduced into his household, or if the marriage had been properly contracted and consummated. Paolo's arguments, while passionate and well-reasoned, fell on deaf ears. The drafters of the 1409 and 1415 statutes disregarded his views, and his minority opinion was not even mentioned by later commentators. Despite this, Paolo remained steadfast in his belief that the statute should be interpreted literally, without considering non-statutory requirements. In another case, Paolo tackled the issue of concurring claims to the dowry by the husband and children from a previous marriage. He argued that the Florentine statutes, particularly the 1415 version, should be interpreted to exclude children from a first marriage from inheriting the dowry, if the husband from a second marriage survived his wife's death and had children with her. This harsh interpretation was intended to make it easier for widows to remarry, a social priority in Florence. Paolo's approach was not without its critics. He clashed with earlier Florentine jurists who believed that the children of a first marriage should be guaranteed their legitima, or a quarter of the dowry, as per Roman law. Paolo rejected these arguments, insisting that the dowry contract could only make dispositions during the marriage, and could not deny the dowry to the children of a first marriage. In a non-Florentine case, Paolo was asked to advise on a decision by an appellate court that divided the inheritance between a second husband and a son from a first marriage. He argued that the statute should be interpreted literally, but he found a middle ground by invoking the ius commune. If the wife had left a last will, her son from the first marriage could still claim his legitima. This balanced approach allowed Paolo to uphold the court's decision while respecting the principles of both local law and common law. Paolo's opinions, while often controversial, reflected a deep understanding of the complexities of Florentine law. His willingness to challenge traditional interpretations and his commitment to a literal reading of the statutes set him apart from his contemporaries. In a city where legal debates were as intense as they were frequent, Paolo di Castro's voice stood out, even if it was not always the loudest. Paolo di Castro, a respected legal expert in Florence during the early 15th century, often dealt with complex legal issues, especially those involving inheritance and property rights. One such case involved a wife who died, leaving behind a dowry and a son from her marriage. The tricky part: the small community where she lived had its own laws, which were now under Florentine rule. In this community, the local law said that the husband should get half of the dowry, but it didn't say what should happen to the other half. Paolo had to figure out what to do with the remaining half of the dowry. He considered several options. First, he thought about using the old Pisan laws, which would have given the other half to the wife's father. However, this community was no longer under Pisan rule, so that wasn't a viable option. Next, he considered the Florentine laws, which said that if there were children from the marriage, the husband wouldn't get any part of the dowry. But Paolo knew that the Florentine laws might not apply directly, because the local community's laws had been approved by Florence. This approval meant that Florence allowed the community to keep its own laws, as long as they didn't conflict with Florence's interests. Paolo then turned to the ius commune, which is a set of legal principles used throughout Italy. According to the ius commune, the remaining half of the dowry would go back to the wife's family because they were the ones who provided it. But this solution would be the same as the Pisan law, which wasn't ideal. To solve this, Paolo introduced the idea of a general custom, consuetudo generalis. This is an unwritten law that can apply alongside written laws. In this case, the custom was that the children of the marriage should inherit the remaining half of the dowry, not the wife's family. This solution allowed Paolo to respect the local community's laws, while also aligning with Florentine norms. Paolo's approach showed his skill in balancing different legal systems. He didn't simply apply Florentine laws or revert to Pisan laws. Instead, he found a middle ground that respected the community's autonomy while aligning with broader legal principles. Another interesting case Paolo dealt with involved a group of people who owned property together. One person wanted to sell their share, and the local law said that another partner who shared a wall with the property could buy it first. However, the person who wanted to buy it had a brother who also shared the wall. The question was whether the buyer needed his brother's permission to buy the property. Paolo interpreted the law broadly, allowing the buyer to act independently. He argued that the law didn't require the buyer to have a full, exclusive right to the wall. Just sharing the wall was enough. This interpretation gave the buyer more flexibility and aligned with the broader goal of the law, which was to protect the rights of partners in common property. In yet another case, someone wanted to donate a patroneria, a type of property right without their partner's consent. The local law prohibited the sale of common property without consent, but it wasn't clear if this applied to donations. Paolo argued that the law should be interpreted broadly, to include donations as well. He explained that if the law only applied to sales, it would be less effective in protecting the rights of partners. Paolo's approach in these cases shows his ability to navigate complex legal issues and find solutions that balance different interests. He didn't always refer to his role in drafting the laws or the intentions of the lawmakers, but his deep understanding of the law and its history allowed him to provide practical and fair solutions. In the city of Florence during the 1400s, a man named Paolo di Castro was a very important lawyer. He was known for his skill in understanding and interpreting the laws of Florence, especially the big book of laws called the 1415 statutes. However, even though he was respected, his opinions weren't always accepted by everyone. For example, there was a part in the laws that talked about something called patronage. Paolo thought this included the church's right to control certain properties and positions, which he believed was very important in Florence. But other lawyers, like Bensiveni, thought it only applied to a different kind of patronage from Roman times, which was about freed slaves. Bensiveni and other lawyers like Stefano Guaspero de Minicis, Giovanni de Gubbio, and Lorenzo Ridolfi argued that the law only covered the Roman-style patronage, not the church's rights. They thought the law's words only meant what they said, without stretching the meaning to include more. Paolo, on the other hand, believed that the law should be understood more broadly to include church patronage because it was so important in Florence. Despite Paolo's efforts to make the law apply more widely, his opinion wasn't the most popular. The other lawyers' views, which limited the law's scope, were more accepted in Florence. This shows that even someone as respected as Paolo di Castro could have his legal opinions challenged and rejected by his peers. Another important figure in Florentine law was Tommaso Salvetti. Born in 1390, Salvetti was a lawyer who studied in Padua and Bologna. He moved to Florence in 1425 and quickly became a well-known jurist. He worked on many important cases, often involving the church, and he was a close friend of the prior of the Badia Fiorentina, a powerful abbey in Florence. Salvetti was known for his detailed commentary on the 1415 statutes, which he wrote to help people understand the laws better. This commentary was so respected that it was called an oracle, and was used by other lawyers for many years. Salvetti's work was especially important because he knew the main person who wrote the 1415 statutes, Paolo di Castro. This connection made his commentary even more valuable. Salvetti's career was closely tied to the Medici family, who were the most powerful people in Florence at the time. He served in many important positions, including as a prior, and he was often asked to help with legal and political issues. One of his most significant contributions was his work on revising the rules for appointing people to political offices in 1441. He was also part of a committee that tried to organize and simplify the many amendments that had been made to the city's laws over the years. Salvetti's commentary on the 1415 statutes was a critical resource for lawyers and judges in Florence for a long time. It helped people understand the laws and their meanings, and it showed how the laws were applied in real cases. His work is a testament to the complex and evolving nature of Florentine law during the Renaissance. In the city of Florence during the 1400s, legal experts or jurists played a crucial role in interpreting and applying the city's laws. One of the most important documents they worked with was the Statutum of 1415, a collection of laws that governed various aspects of Florentine life, from civil cases to criminal offenses. Jurists and advocates often made marginal notes on copies of the Statutum, sharing their insights and experiences to help others understand the laws better. These notes could be extensive, sometimes covering large portions of the text, and they were continuously updated by different jurists over time. Alessandro di Salvi Bensaveni was one of the first jurists to write a comprehensive commentary on the Florentine statutes. Around 1423, he wrote a collection of comments or annotations on the second and third books of the Statutum. These books dealt with civil and criminal cases, respectively. Bensaveni's work became a model for future jurists, who began to write their commentaries as separate texts rather than marginal notes. This new format allowed for more detailed and structured analysis of the law. One of the most notable successors to Bensaveni was Francesco Salvetti. Salvetti started working on his commentary around 1448, focusing on the second book of the Statutum, which covered civil cases. His work was more detailed and thorough than Bensaveni's, and it quickly became the standard reference for Florentine jurists. Salvetti's method involved drawing on his vast experience as a legal consultant and scholar. He used a variety of practical texts, including concilia legal opinions from earlier decades, to support his interpretations of the statutes. Salvetti's commentary on the second book was preserved in several manuscripts, including one in the Biblioteca Medici Lorenziana and another in the Biblioteca Marciana in Venice. These manuscripts show that Salvetti's work was widely read and copied, often with additional notes added by later jurists. This open nature of the text meant that it continued to evolve and grow over time. In addition to his work on civil cases, Salvetti also wrote a commentary on the third book of the Statutum, which dealt with criminal cases. This part of his commentary was completed later, likely in the 1450s or 1460s. It focused on procedural issues and specific types of crimes, particularly those involving violence. However, this part of his work did not become as influential as his commentary on civil cases, possibly because of changes in criminal law in the following decades. Salvetti's commentaries were not just technical legal analyses. They also reflected the political and social context of Florence. For example, he often cited cases involving the Medici family, who were the dominant political force in the city. Salvetti himself had close ties to the Medici, and his commentary includes references to his personal involvement in legal matters related to the family. He also commented on political decisions made by the Florentine government, sometimes criticizing them for not following the advice of legal experts like himself. One notable example is Salvetti's discussion of the Catasto of Volterra in 1427. The Catasto was a tax system, and Salvetti and his colleague Nello da San Gimignano advised the government on how to handle exemptions for certain places and people based on earlier agreements. However, the government ignored their advice, leading to a rebellion in Volterra. Salvetti saw this as a failure of the government to listen to expert legal advice, which he believed could have prevented the conflict. Another case involved the arrest of a Neapolitan ambassador, Angelo Morosini, who was passing through Florence. Despite Salvetti and Domenico Martelli arguing that the ambassador should not be detained due to his diplomatic immunity, the government proceeded with the arrest. This action angered the King of Aragon, leading to a military threat against Florence. Salvetti used this example to emphasize the importance of following legal advice to avoid political mistakes. Throughout his commentaries, Salvetti presented himself and his colleagues as guardians of legal expertise, working to ensure that the Florentine government made informed and prudent decisions. While the government did not always follow their advice, Salvetti's work remained a respected and influential source of legal knowledge for many years. His commentaries helped to bridge the gap between the abstract principles of the law and the practical realities of legal practice in Florence. In his work, Martins suggests that the rise of lawyers in 15th-century Florence was not just about the growth of the government's power, but was also a tool used to build the modern state. The legal culture in Florence, heavily based on local laws and traditions, played a crucial role in this process. Salvetti, a prominent lawyer, contributed significantly to this by interpreting and explaining the city's laws, making them more effective and practical. His work showed that while lawyers were tools of the state, they also had room to express their professional identity and influence the structure of the state itself. Salvetti's interpretations of Florentine laws were so influential that they lasted for centuries, even when other Italian cities had moved on to new legal systems. This long-lasting impact of Salvetti's work highlights the deep connection between the legal profession and the state's development. The state relied heavily on these lawyers, and their interpretations shaped the legal and political landscape of Florence. Thomas Kuhn expands on this by focusing on the role of legal opinions, or consilia, which were written by lawyers to advise on legal matters. These documents, often overlooked by historians, provide a window into how lawyers influenced both public and private life in Renaissance Florence. Kuhn emphasizes that while Martins looked at how lawyers shaped statecraft, consilia also offer insights into the everyday lives of Florentines, especially in areas like family law and social dynamics. For example, Kuhn examines a set of legal opinions from the early 1400s that dealt with dowry restitution. These opinions show how lawyers navigated the complex legal and social norms surrounding marriage and inheritance. The case involved a widow seeking to recover her dowry after her husband's death, and the lawyers had to decide whether the husband's brothers, as co-heirs, were responsible for returning the dowry. This case highlights the intricate relationship between local customs, legal principles, and the practical needs of individuals. Kuhn also notes that the legal profession in Florence evolved over time. In the early 15th century, many lawyers were from outside Florence, bringing new perspectives and ideas. By the end of the century, the legal profession was dominated by Florentine families, reflecting the city's growing political and social stability. This shift coincided with changes in the Florentine legal system, such as the reduction of foreign judges' influence and the creation of new courts. Overall, the work of Martins and Kuhn shows that lawyers in Renaissance Florence were not just passive instruments of the state, but active participants in shaping the legal and social fabric of the city. Their interpretations and advice had a lasting impact, influencing both the state's development and the daily lives of Florentines. The story of lawyers like Salvetti and the consilia they produced is a testament to the enduring importance of legal culture in the history of Florence.